Hey everybody, Paul Rebeley here, and this video is about the enforcement of claims against successions. Really a procedural video, but important if you're involved in the settling of an estate in Louisiana. Maybe a loved one died, and that loved one may have had some assets, but they also had some debts, and you're wondering how, what is a debt and what debts have to be paid. Or maybe somebody died and they owed you some money, so you're a creditor, of the succession, and you want to know how to kind of stake your claim to the succession assets so that you can get paid. So I'm going to tell you here an area where if you're involved on either side of the equation, you're going to want to get an attorney. And what I'm also noticing here in the background as I look at the camera is there's a box of fine pastries and chocolates. It's my birthday in 2 days, and so somebody got me some really good stuff. I already ate most of it from Baum's Fine Pastries and Chocolates from 1934, since 1934. Free plug there. Okay, so here's the deal. This is the procedure that people really must follow to when there's some claims against a succession. So the first thing that typically happens is the creditor, can submit his claim to the succession representative. Let me define succession representative, because when successions are being what's called administered, then if there was no will, a judge appoints an administrator. If there was a will, typically there was an executor named in the will, so the judge confirms the executor. Same role, just different title depending upon whether there wasn't a will, administrator, was a will, executor. Now, in addition, we have something called an independent administrator or independent executor, but really these enforcement of claims against succession rules apply the same whether they're independent or not. So all of those titles fall under the succession representative. Okay, so the first thing that happens is the creditor can submit his claim to the succession representative, and it needs to be in writing. No other form requirement for purposes of just submitting the claim. Now, the succession representative, once they get it, they have 30 days to either acknowledge the claim or reject it. And if they don't do anything, it's considered a rejection. So if the succession representative acknowledges the claim, says, yeah, you're right, he did owe you $30,000 when he died, then what that does is that acknowledgement allows the claim to be included in all of the succession paperwork for payment. And it also creates a presumption that the claim is valid even if that claim is not listed in the succession paperwork. And it suspends what's called the running of prescription against the claim as long as the succession is what's called under administration. So an acknowledgement is pretty simple. Hey, succession owes me money. Succession says, yeah, you're right. That debt is acknowledged. That's going to be taken care of. So that one's pretty easy. Now, sometimes it's either rejected either through a written rejection or a lack of response by the succession representative over the 30-day period. So then the creditor is going to want to suspend what's called that running of prescription so that that debt is still out there and it doesn't expire, for lack of a better term, or prescribe is the legal term for it. So a creditor can suspend that running of the prescription for up to 10 years by delivering to the succession representative or their attorney of record a formal written proof of claim. We'll talk in a minute. Well, let's talk now about what a formal written proof of claim is. So claim is rejected. Creditor suspends running a prescription by delivering to the succession representative a formal written proof of claim. That's something that's sworn to by the claimant. It has the name and address of the creditor, the amount of the claim, and a short statement of the facts. And then if the claim is secured, it describes the security for which the claim is secured by. So the creditor suspends the running of a prescription by delivering to the succession representative the formal written proof of claim, or by filing a formal written proof of claim in the succession record if no succession representative has been appointed and there's been no what's called judgment of possession. And then sometimes, no succession has even begun. And so what's a creditor going to do? They're just sitting there. There's no succession open. Well, the creditor can file a formal written proof of claim in the mortgage records of the parish where the deceased person was domiciled. So that's another option that they have. Note that there is in our law a provision where a creditor can be appointed the succession representative. So that, I guess, would give the creditor the upper hand because they're not only the creditor, but they're the succession representative, and they can acknowledge or reject debts. And of course, people can question all of that as part of the administration. So anyway, that basic information ought to get you started if you have that situation. Said it before, I'll say it again. If you're in that situation, get a lawyer who understands these rules and can work with you the right way, get it right the first time. It doesn't do any good to get on top of a building and just scream and holler about your problem. You got to follow the procedural rules in order to get the kind of results that you expect and you deserve. So, hope that helps. This, doesn't come up a whole lot, but when it does, got to make sure you follow the rules for the third time. Make sure you see an attorney who is able to walk you through this in the right way. So hope that helps. Hope you're good with my kind of informal attire. It's here on a Friday afternoon, heading out in just a little bit to an LSU baseball game at the box. And y'all have a great day, great weekend, whatever the case may be. Go Tigers. See ya.